All right. So before we get to chapter 4, last Wednesday, we talked about dispute resolution. So we would solve disputes. We started looking at alternative methods to court litigation. Can you help me remember what those methods are? And they don't need to be in sequence. How do you solve a dispute out of court? Negotiation, mediation, and arbitration. So negotiation and mediation, the outcome, the decision is not binding on the parties, but the decision for arbitration is binding. It is known as an arbitration award. Okay, it's similar to a court decision, even though it's not. And then we talked about court litigation. And can you help me remember what is the highest court in Canada? The name of the highest court in Canada? Supreme Court of Canada. So the highest court. Where is the Supreme Court of Canada located? Ottawa, Ontario. So because they are the highest court in the country, all their decisions, they will become precedents. Remember, case law, they are binding. Now, within a province, let's focus on BC. What is the highest court in BC? Yes, the Court of Appeal of BC, or the BC Court of Appeal. So you will remember that the Court of Appeal, they review cases. So when a party loses in the trial level, they may appeal to the Court of Appeal. And the decision of the Court of Appeal, when it is final, it may also create a precedent. It may. Okay. Sometimes this decision from the Court of Appeal, they go further to the Supreme Court of Canada. Not all appeals will reach the Supreme Court of Canada. You may remember this. Only cases of national interest. So few cases will go to the Supreme Court of Canada. Now, the last question here. What is the highest trial court in BC? The BC Supreme Court. And the BC Supreme Court is the highest trial court because it takes jurisdiction over matters of unlimited monetary amount, over $35,001, right? So they are the highest because below them, there's still the small claims court, matters from $5,001 to $35,000. And which is the one up to 5,000? Which one? Don't be afraid. CRT, Civil Resolution Tribunal. So matters up to 5,000, they may go to the CRT. Okay? So you should also remember that at the trial level, matters of fact will be decided. And in an appeal, you may remember that the Court of Appeal, they will mostly likely review matters of law, questions of law. So you may remember that, is it sunny outside? Is this a question of fact or law? Fact. That's fact. Was the driver drunk? Also fact. Well, as the exercise we saw, one of the questions we saw last week, was he justified to hit back, to self-defend himself? The justification under law is a question of law, right? So questions of fact, questions of law, you should remember. Once you win a lawsuit, you have to enforce it if the losing party does not pay voluntarily. So there's an enforcement procedure. So you may invite the losing party to court, so the judge will interview that losing party to learn whether they have assets, cash, whether they work. If they have assets, the judge may seize those assets and then sell in public for the public, and then the proceeds will be used to pay compensation. You should also remember that in most cases, in a lawsuit, in a business lawsuit, parties will be seeking money, monetary compensation. So we saw three main types of damages. We saw special, general, and punitive. So you should remember what they are. Okay, the difference. Special, precisely costs. The costs are the damages you actually suffered. General, future, pain and suffering. Punitive, to punish the wrongdoer when there's malice, bad faith. So the idea is to punish. What else? Well, we saw several details on the litigation process. I told you you don't need to focus on the details, but at least know some of the names and understand the procedure. We also saw class actions, and we ended the lecture looking at regulatory bodies and administrative tribunals. The best example or the easiest example for the administrative tribunal would be the Human Rights Tribunal. For a regulatory body, it could be the municipality, could be Health Canada, could be the Patent Office. So I gave you some examples. And you must remember the natural justice rules, rules of natural justice. Everyone has a right to be heard. The decision maker or the person who hears the evidence, they must make a decision, and the decision maker cannot be biased, cannot side with one of the parties. Okay, so that's a very brief summary on chapter 3. So now we start chapter 4, and in chapter 4. So from now on, we're going to be looking at specific legal topics. Torts this week, contract law for the next 2 or 3 weeks, and then business organizations, IP, etc. So we'll start with torts. And you may note that the knowledge we had in chapters 2 and 3, they may be needed here. We need that knowledge here. So in chapter 4, we're looking at intentional torts and some business torts. Well, first of all, let's define what tort is. Tort is this social or civil wrong. So someone who acts wrongfully, in a wrongful way. And by acting in a wrongful way, they may cause harm, injury, losses to others. And the victims, they will then, under tort law, they will have a remedy. They will have the possibility to seek for compensation. Simplest example right away would be car accident. In a car accident, one hits the other. The driver at fault, they cause losses to the other driver. They cause injury. So under tort law, they may be compensated. I know it's car accident here in BC, there's ICBC, there's a lot of insurance aspects there, but I'm just giving you a very rough example. Okay, when one causes loss to another, and then under tort law, the victim will seek compensation. In most cases, compensation. This acting wrongfully may be intentional or unintentional or careless. The car accident would be a careless example. Or do you think drivers, they hit others intentionally? Most likely not, right? In most circumstances, they were careless. They were texting and driving, talking to someone, they lost attention, thinking about something else. And intentional, we'll see several intentional torts today, such as battery, such as assault. So we'll see when someone acts wrongfully in an intentional way. So one of the main objectives of tort law is to allow a tool for the victim to seek compensation. It also works as educating society, because if I know that under the law, if I cause harm, losses, damages to others, I may need to pay compensation, this may also educate me, this may also educate society as a whole. But the main objective is to provide victims a compensation tool, a compensation mechanism. We need to differentiate a tort from a crime. Sometimes a tort will also be a criminal offense. But a criminal offense is that conduct that is prescribed, that is detailed in the criminal code. So if the criminal code says that killing someone, it's a criminal offense, so that's a criminal offense. A tort is whenever someone acts wrongfully and causes harm to others. A criminal offense actually is also a social wrong, as we just saw here, but it is a social wrong that affects society as a whole. The government is out there, theoretically, to protect us from criminals, okay, from criminal offenses. But there are circumstances in which the criminal offense may also be a tort. And I gave you an example last week, but I'll give you an example again. So let's say during the break, you leave your smartphone in class and someone steals your smartphone. Is theft a criminal offense? Yes, it is. But by having your smartphone stolen, did you suffer a loss? Yes, you did. $1,000, $2,000. So, because we learned last week that in a criminal offense, what does the victim do in a criminal offense? If you are a victim of a criminal offense, what would you do?
Go to the authorities, the police.
Yes, you go to the authorities, you report to the authorities, police, and they will take it from there. You don't recover anything from a criminal proceeding. So for you to seek compensation for the loss you suffered, you have to sue the accused. You sue the accused under tort law. So one conduct, one social wrong, which was stealing a smartphone, gives rise to both criminal proceeding and tort law. Right? Tort for compensation. The victim will sue the accused. Criminal procedure, the government, prosecutor, they will pursue the accused. Okay, we saw this. And you may remember that tort law is based on balance of probabilities. So it may be easier for the victim to establish they suffered a loss based on the balance of probabilities, as opposed to the prosecutor to establish that the accused actually committed the crime. What is the burden of proof in a criminal offense? We saw this last week. Which one?
100%?
Yes, but how do we call it? It's almost 100%. So how do we call the burden of proof in a criminal offense?
There must not be a single doubt.
There can't be a doubt. So we call it beyond a reasonable doubt. So for a prosecutor to be successful, they have to establish the accused committed a criminal offense beyond a reasonable doubt. But for a plaintiff to be successful in a tort lawsuit, they have to establish they suffered a loss based on a balance of probabilities. So more likely that they suffered a loss than not. Okay, so this is also important. One last thing here is we're going to talk about contract law starting Monday next week. But for now, we should keep in mind that tort is not breach of contract. A breach of contract is when one party in the contract fails to perform their obligations satisfactorily or fails completely. So a breach of contract, first of all, requires a contract. So parties need to be in a contract. So if I'm driving, again, the car accident, if I'm driving and I hit someone else, am I in a contract with the other driver? No, I'm not. So it cannot be a breach of contract. It may be a social wrong that is a tort. And a breach of contract not necessarily is a wrong, is a social or civil wrong. Again, a breach of contract is usually when the party fails to perform the obligation as agreed. So what I just did with you was to differentiate what a tort is, and I differentiated a tort from a criminal offense from a breach of contract. Okay, so this difference is important. Now, as I said before, torts, they may be intentional or unintentional. We'll be focusing on the unintentional torts, negligence, on Wednesday. Today, we're going to look at intentional torts and some business torts as well. This is just a review from last Wednesday. So special damages, the ones that the victim actually incurred, suffered. General damages, usually for pain and suffering or future damages. Punitive damages to punish the wrongdoer. So if you act in a way with malice, with bad faith, you may have to pay punitive damages. You may. So this is just a review from last Wednesday, damages. Vicarious liability. We also saw this, or did we see? No, we did not. So vicarious liability, what is this? This is when one party that is not at fault, they are liable for the social wrong of another, for the wrongful conduct of another. So one party that is not at fault, they are liable for the wrongful conduct of another. Best example is employment relationship. When an employee acts wrongfully, their employer is vicariously liable. Vicarious liability is more protection for the victims. So let's say, while delivering this lecture, I hit your screen and your screen is damaged. Because I'm delivering the lecture, because I am performing my job duties, you, the victim, you can sue me and also my employer, BCAT. You will sue both if you want, or you can sue only me. You cannot recover twice. But because you are suing two, your chances to be compensated are high, right? don't you agree that I am, no, not me, but don't you agree that BCAT is likely richer than I am? So if I cannot pay the judgment award to you, BCAT may be able to pay. And then BCAT, later on, after paying out the compensation to you, they could turn back to me and sue me to recover their losses. Employers usually don't do this because they have insurance. But they could also start a progressive disciplining on me because I caused losses to clients or to third parties. Okay, so that's vicarious liability. It's more protection for the victims. Another example I can give you. Owner of the car and driver. Who owns a car here? All right. So if someone else drives your car and they are involved in a car accident, let's forget ICBC here, okay? If they were at fault, the victim could sue them, your friend, and could also sue you, the owner of the car. Because owner of the cars that are driven by someone else, they are also vicarious liability. Is this clear? So this poses legal risks to employers. If you are an employee, you may be causing your employer losses. If you are an employer, if you are a business owner, you have employees, you may be liable for the losses caused by your employees. Okay? All right, so let's start with intentional torts. I will not be able, or I'll probably not be able to give you all answers to all questions you may have, but I'll be trying to go through all torts, giving you examples, discussing some scenarios, okay? But my explanation is not an exhaustive list. In the textbook, you have even more examples, and by the way, the examples help a lot to remember the concepts. So we start with intentional torts. So intentional torts, when the conduct was intended or deliberate. So I wanted to act like this. I actually wanted, I was aware I was acting wrongfully and I still went ahead. So the first types of tort we look at will be trespass to person. So torts that are against people, and we'll have assault and we'll have battery. Disclaimer here. There's a criminal offense of assault. I am not talking about the criminal offense of assault. I'm talking about the tort called assault. Okay, so it's important to differentiate. The requirements for a criminal assault are different. The concept is different. So in tort law, an assault is when we are threatened. We are threatened to be struck. So I have my clicker here. If I threaten to throw this at you and you find yourself to be struck, you were a victim of an assault. That's it. I haven't thrown this at you. I just threatened to throw. You were a victim of an assault. Or if you were to start a fight, you haven't started, but you are about to start a fight, the other person was also assaulted. Okay? So if someone is following you, calling nasty names, and you find yourself threatened to be hit, you are also assaulted. Again, assault in tort law may also be assault in criminal law, but I'm not focusing on criminal assault. Okay? And then battery. Battery is when there's actually the physical contact, the non-wanted physical contact. So if I actually throw this at you and this hits you, it is battery, not assault. Why? Because it hit you. So battery is when someone is touched or hit in an unwanted way without consent. Okay, so the difference here will be the physical contact. If there was physical contact or the unwanted physical contact, it's battery. If there's no physical contact, but there was this threat of being struck, it's an assault. Okay, so we read in the news someone was assaulted at transit, SkyTrain, or at a park. Well, most circumstances that assault is the criminal one. Most, not all, but at least now today you are learning what a civil law, private law, tort law assault means and what battery means. If someone sends you emails threatening you, or Snapchat messages, or any social media, and they're threatening you seriously, you may also be a victim of an assault. Okay, you can sue them for compensation. Could also be criminal offense, depending on how serious it is. So, what are the defenses for the torts of assault and battery? The first defense is consent. Actually, consent may be used for several torts we'll see today. Well, if the victim has consented, let's say we agree to have a play time here, and our game is about throwing objects at one another. So you agree. When I threaten to throw this at you, it's not an assault because you consented. Okay? So consent is a defense. However, consent has to be voluntary, has to be informed. Well, you know what may happen, and has to be voluntary. Voluntary is the opposite of under threat. So I cannot threaten you to consent. It has to be voluntary. Okay? If you accept to play hockey, you are accepting some kind of, not violence, but physical touching, physical contact with another, because that's how hockey is. If you're fighting at UFC, or if you're fighting in boxing, you are accepting, you are consenting to some, or to violence at some extent, not exaggerated. Okay, so consent will be a valid defense if there is one. And self-defense can also be a valid defense as long as the force that is applied is reasonable, is not excessive. So let's say, you know that in Texas, people can carry guns, even inside a classroom. So let's say we are in Texas, I make a joke with one of you, and you take out your gun and you shoot me 10 times. Is this reasonable self-defense? No, it is not. Okay, and I'm exaggerating on purpose, because my message here is that a reasonable self-defense is the one that you stop the threat. Whether your force was excessive or reasonable will usually be a question of law, not a question of fact. So this will change, or this will be decided on a case-by-case basis. Okay? So I see a child trespassing to my backyard. So I go there, I talk to the child has no weapons, nothing on their hands. Hey, you cannot be here, will you please go out, and I accompany them. This is self-defense, reasonable. But if I then get a baseball bat and I hit them, or if I get my gun and I point at the child and say, hey, come on, live, they may not even know what a gun is. So has to be reasonable. There will be other examples during other torts. I'll give you more about reasonability or not. Are those two defenses clear to you? All right, so that's trespass to person. Now trespass to land. This is when we are at someone else's land without their authorization, without their permission. So this is trespass to land. It could also be throwing objects, throwing garbage at someone else's land. This is also trespass. And there's one defense available here. The defense is if you end up at someone's property, either by consent or accidentally. So accidentally you end up at someone's property. Could be an accident, a car accident, and your car ends up at someone else's property. Then it's not trespass. Or it is, but you have a valid defense because it was not intention, was not willful. Okay, so that's trespass. There's another example on trespass, which is, do you know down close by shopping mall? So you go there and you start not behaving well. You and your friends are not behaving well. You're running, you are jumping, you're pushing people. So security guards will approach you and will say, hey, stop doing this or leave. And then you don't stop. So they come back again to you and say, hey, leave, now leave. When they say leave, they are revoking your authorization to be there because you were there and it's their land. But because it's a shopping mall, we have implied license. We don't need to ask their authorization to be there. But as long as we start not behaving well, they may revoke our license. Then when they revoke our license, if we keep on being there, they may expel us. They may remove ourselves from the place. And if we don't leave, we are trespassing. And as a self-defense, they can't physically remove us. But again, as a self-defense, they need to use the necessary force. They cannot use force more than they needed. So for example, let's say they are removing me and they throw me down the stairs. This doesn't seem to be necessary. Or if I'm outside already, and then security guards come and punch me and hit me and kick me, this is excessive because I'm already outside. Okay? So in those circumstances, even though I was trespassing, but when I was removed, I was a victim of excessive force. I could sue back for, what would I sue back for? If I am hit? Battery. Yes. Not assault because there's physical unwanted contact. So I would sue for battery. The same applies for a bar. You go to a bar, you know that servers, they have a duty and also an obligation to stop serving someone who is visibly drunk. And then they ask the person to leave. If they don't leave, security guards may remove them. But if they remove them with excessive force, they may be sued for battery themselves. Okay? All right, so that's trespass to land. Now let's look at goods, things. And this is chattels. So this word here, chattels, they mean the same as goods. Chattels and goods are the same. So your backpack, your smartphone, laptop, pen, tablet, notebook, those are all chattels or goods. Okay, so the first one is trespass to chattels. So when our goods are interfered with, again, my example, I'm here and just because you came late, I'm mad at you, so I'm gonna hit your screen. Is this trespass to chattels? Could also be a criminal offense because you were also assaulted, whatever it is, but now I'm focusing on the chattel aspect, on the goods aspect. So if I interfere with your goods, or in a car situation, so you cut me, I get mad at you, and then when I have a chance, I get off my car and I hit your car. Could be trespass to chattels. Again, I'm not talking about criminal aspects here. I'm talking about private law, tort. So when our possession and we own something is interfered with by someone else and causes us loss, damages. There's also conversion. And conversion, let's use the word here. Conversion comes from convert. So when I convert property from someone else to myself, illegally. What is this? What is to illegally convert your property to myself? What criminal offense is this? It's a theft. When I steal something, I get something that belongs to you to myself. So I convert it to me. So conversion is the theft, but in tort law. Because this is related to tort law. So my example, when we went on a break and your smartphone was stolen, so you report to the police about a theft of your smartphone, and then if the accused is ever found, the person who stole your smartphone is ever found, you can sue them for monetary compensation, the loss you suffered under conversion. Right? So that's conversion. Now that new. So that new, again, the word that new here is to detain, retain, detain. So now is different. Now I have legal possession of goods. The goods don't belong to me, belongs to someone else. But I have the legal possession. And the civil wrong, the social wrong is related to not returning the goods to whoever it belongs. So when do you have something legally that does not belong to you? Can you give me an example? Library book, as simple as this. Library book belongs to the library. You borrow it, and if your intention is not to return it, is to keep it with you, they may sue you for debt. Okay? Again, we're not talking about the criminal offense, even though this may also be a criminal offense. Another simple example here is you go to Vancouver downtown, and then because it's a tourist city, you want someone to take a picture of you. So you give your smartphone to someone to take a picture. Are they stealing your smartphone when you give your smartphone to them? No, they are not. You are giving it to them. Then they take your picture and they go far away and then they run. So they did not steal, but they showed a conduct that they didn't want to return. They want to keep the phone to themselves. So you would sue them for debt, not conversion. Conversion would be the pickpocketing. When someone illegally gets something that belongs to others. And then that new, you have the legal possession, but then you do not return. Are we good so far? Okay, now false imprisonment. Well, false imprisonment is when we are restrained, physically speaking, without our will. So if I lock the doors now, if I lock the doors and I say no one leaves, and you don't want to stay here, it may be false imprisonment. When does this happen? Can you think of a situation where people were stopped from leaving, from moving? Department stores, grocery stores, shoplifting. Someone is suspect of stealing something in the store. When they are leaving, security guard stops them and they want to search them. And then after searching, if they don't find anything, the victim, the shopper, is a victim of false imprisonment. Okay? So you should only stop and search someone if you are sure they have committed a criminal offense. If you are not sure, you should not stop. Even though this may motivate or cause even more shoplifting, but still, on a legal risk perspective, you should only stop and search people if you are sure they have stolen something. If you commit the tort of false imprisonment as an employee, as a security guard, is your employer liable? Yes, they are, based on vicarious liability. So based on vicarious liability, an employee who commits the tort of false imprisonment, they also make their employer liable. So I could search you, but I could also use my authority. So even if I don't, I'm using you as an example, so I'm going to use you now. Even if I don't touch you, but I just say, don't move, stay there. And if you submit yourself to my authority, this is also false imprisonment. Maybe I'm not blocking you physically, but I'm just saying, don't move, stay there. This could also be false imprisonment. Okay? What is the defense available here? Well, the defense, if you actually catch someone who has stolen something, because under the criminal code, we can arrest others. So we citizens, we can arrest others as long as they committed a criminal offense. So as a security guard or as, I don't know, instructor, a regular person, an individual who has seen someone stealing something, they have that stolen goods with them, I can arrest them. But right away, I need to call the police because I cannot keep them for long. Okay? Another thing is, usually employers, they tell their employees that only security guards should stop and search people. Because the risk for injury, for losses, is a bit high. So as an instructor, I don't know how to search people. I don't know how to stop people. So if I try to stop someone, they may have weapons, they may have a knife, a gun, and they may injure me. And then the loss for my employer may be even higher. So let's say they stole $50 gift card, but then my injury will cost my employer, will cost whoever it is, thousands of dollars. Again, I know it is against educating society, but that's how the law is. So as a business owner, I would have only trained employees to stop and search people, not everyone. Even if a regular salesperson saw someone stealing, don't stop, don't search. Call security, call manager, but you don't do anything with it. Okay. All right. So now, malicious prosecution. Are the examples helping you? Are you connecting to the concepts? Okay. So in your exams, I expect you to remember the concept and then know how to apply them. You see this in the quizzes for chapter 4. So I'll give you a small case scenario, and then I want to know if this is an example of a battery, of an assault, of a trespass, or what the defense is, etc. So malicious prosecution. This is common to prosecutors, but it could also be happen to other people. I'll give you an exaggerated example here. Let's say I fabricate evidence, I create evidence that my neighbor is a drug dealer, because I don't like my neighbor actually. So I fabricate evidence, and I report him to the police. And then with my fabricated evidence, prosecutor actually laid charges on my neighbor. My neighbor is arrested for some time, but then at the end, my neighbor is acquitted, not found guilty. And during the criminal proceedings, it is found out that I have fabricated the evidence against my neighbor. I did this out of malice because I didn't like my neighbor. I want my neighbor to have trouble in law. But my neighbor was not a trustee. So after being acquitted, after not found guilty, my neighbor can turn back to me and sue me for malicious prosecution. Because I used the system, the justice system, to cause bad to someone who didn't do anything bad, actually. Okay, this is not so common, but that's what it is, malicious prosecution. Using the just system with malice to cause trouble, to cause problems to others. Okay, there's an interesting case in your textbook you may read. One fabricated evidence against their partner, no, not the partner. The one is the employer. The employer had a recording of the employee stealing, but actually the employee was exchanging money, exchanging US dollars for Canadian dollars. And they reported the employee to the police. And when they sent the video to the police, they actually suppressed part of the recording. The employee was later found not guilty because the employee had actually taken money, but to exchange for another currency, not to steal money. So the employee was awarded almost $2 million when the employee sued back their employer for malicious prosecution because the employer did on purpose the suppressing of the evidence. They knew there was no theft, but after they had reported, they didn't want to go back, so they decided to proceed. Okay, so another example here on malicious prosecution. Now, private nuisance. Private nuisance is when our right to enjoy our property is interfered with by someone else. So I have a swimming pool, and then there's this neighbor flying a drone every time my family and I are in the swimming pool. So they are interfering with our right to use our swimming pool because they are surveilling us. This is an example of private nuisance. It's not that because my neighbor was flying the drone once, twice, even 5 times that I could sue them. No, I should talk to them, I should send them a notice. But if they keep on doing this, then I would be able to sue them. Other examples could be during the fall, when the leaves fall and they are dry, so people put fire on the dry leaves. And then again, I'm trying to use my swimming pool, but there's a smoke, there are ashes coming, so they are interfering with my right to use my property. Okay, I'm giving you very simple examples, but cases of private nuisance, they are not so common. Okay, because usually we solve them out of courts. We solve them with the strata manager, we solve them directly with the other person, but then if we are not successful, then we go after them in courts. Okay? It is called private nuisance because there's also public nuisance. But in this course, we don't go through public nuisance. Public nuisance would be public property. So here, the interference has to be substantial, has to be unreasonable. So it's unreasonable that someone is flying a drone every time my family and I are trying to use the swimming pool. And if they do this regularly, so it becomes substantial. So I may be able to sue them for private nuisance. Now, defamation. So we discussed a little bit about defamation when I shared with you our freedom of opinion, freedom of expression under the Charter. So defamation is when there's a statement that is either false or detrimental about someone, so it has to be related to the person in question, to the plaintiff, and it has to be published. Published, actually, it has to be spoken to another person. Published here is a broader sense. So let's say if there's only Diego and I in the classroom, only the two of us, and Diego calls me a drug dealer, it is not defamation. I am not, it's false statement, but he's calling me directly. He's not telling this to a third party. So it's not defamation. But if we are here with all students, and then Diego calls me a drug dealer, then this may be defamation. Even if there's only one other person, okay? So another person, other than the plaintiff, other than the victim, is required for defamation. And it's usually a false statement. But it could also be true, a true statement, but a true statement that is detrimental. A true statement, for example, let's say Brazilians here in the lower mainland, they have a very bad reputation, low reputation. For whatever reasons, I don't know. And then someone says, hey, this Brazilian instructor again. Yes, I'm Brazilian. But they are saying, they are referring to me as a Brazilian instructor in a detrimental way, to compare me with the Brazilian reputation around. Okay? Those cases are not so common, but could also be. So a statement that is true, but still detrimental may give rise to a defamation lawsuit. There's slander and libel. So this is a categorization with regards to the record, to the evidence. So slander, you see, I have underlined the S because slander is spoken. Slander, spoken defamation. With slander, because it's spoken, the way to prove the defamation is usually by witness, because there's no permanent record. Someone just called me a drug dealer. No permanent record. And it's going to be a libel, usually written. And with a libel, there's usually a record of the defamation. Okay? And so it's just a category, but both slander and libel, they are defamation as a tort. Okay? If it's online, we call cyber libel. So that's what defamation is. Usually false statements about someone, about the victim, about the plaintiff, spoken to at least one other person. Very common online, unfortunately, common in newspapers, magazines, etc. What are defenses? Well, if someone is suing you because you issued a false statement about them, your best defense is actually to prove that the false statement is not false, it's true. Then you have a full defense. You're out. Okay. Another defense will be privilege. But there are two types of privileges. One is absolute. Absolute privilege. You can remember politicians. So politicians in the parliament, in the assembly, the provincial assembly, they are free to issue statements about others. And even if they say a false statement because they are doing this as a politician in the debate room, if they are ever sued for defamation, they have the absolute privilege defense. This exists theoretically to protect democracy, so that different parties, movements can speak freely to one another. Okay, so it's protection for democracy in general. The qualified privilege, This is when there's a special relationship between the defendant, the one issuing the false statement, and the plaintiff, the victim. So the best example, I'll give you an example here in class. So the flexible learning coordinator, she wants to know about your performance. So she writes an email to me and CCing you as well. So when I write to the coordinator, I issue a false statement about you. But the fact that I issued that false statement, it was by mistake, not out of malice. I made a mistake. I told her that you are missing classes because I see you consuming drugs all the time before class. This is a false statement. This is detrimental to you, defamatory. So then, but it's out of mistake. It's mistake, not malice, because I actually saw you, but friend of yours was smoking, not you, but I thought it was you too. So I told her. So you sue me for defamation because I told her that you smoke or you consume drugs. Then in my defense, I will say, hey, it was a mistake, out of malice, and I only issued that false statement to the coordinator of the flexible learning studies. I didn't say it out loud to a class or to a larger group. So because the coordinator and I, we have a professional relationship, and again, it was by mistake, not out of malice, I may have the qualified privilege defense. Another example is your family doctor. Your family doctor wants to refer you to a specialist. When we are referred to a specialist, there's usually a note. Hey, please see this patient for this, and that. So while referring, let's say in the note, there's a false statement about you. Again, this could be defamation. If you sue your family doctor will say, hey, it was by mistake, out of malice, and it was only issued to the specialist. So they may also raise qualified privilege defense. Are we good? Two more, fair comment. So we have freedom of opinion. So yes, you can tweet, you can talk, you can say that the B-Law class is boring, the B-Law instructor is not good, has a bad voice, no activities, etc., etc. It's your opinion. Fair comment, you can do this. But you cannot issue false statements on me. You cannot say the B-Law instructor is a illegal worker in Canada, or is a drug dealer, or harasser, or whatever false it is. So there's a difference between your opinion and a false statement. You can also say that you can create a website such as IHateTimHortons.ca, and you can invite comments, people who had bad experience at Tim Hortons. As long as their experience, their comment, their statements are comments and they are true, it's okay, fair comment. But if they are false, if they say Tim Hortons offers coffee that comes from slavery farms, that this is false, then it's not protected here. Last defense will be public interest responsible journalism. So this was created by the Supreme Court of Canada. So a precedent, it's case law. This exists to protect journalists or newspaper companies, magazines, when they make a false statement, defamatory statement, but out of mistake, no malice, the matter of their article was of public interest, let's say corruption, bribery, things that are of the public interest, and they were responsible in a way that they tried to hear the plaintiff, the victim's version of the story, but the plaintiff has refused to speak with them. And they also have a history of serious non-defamatory statements. So if you can meet all those requirements as a journalist, as a newspaper company, you may be able to get away from a defamation lawsuit out of this public interest responsible journalism defense. This was created by, again, it's case law by Supreme Court of Canada. Okay, so those are defenses available for defamation. Question for you. True or false? That's false. You're right, because they accidentally crash on another person's property. Okay, so that's false. One thing is, let's say you're running from a bear. We're in Canada, so bear is relevant. So you're running from a bear and you enter someone else's property. Is this trespass? Running from a bear? Yes, it is. It's trespass. You can't. Obviously, if you don't cause any damages to the property owner, they may sue you and compensation may be minimal, if any. But yes, if you're running from someone, from a bear, from some danger, and you enter someone else's house without their authorization, it is trespass. Okay? Just accidentally. I know that, you know, the polar bear, there's a city, a famous city in north of Canada, Yukon maybe. People don't lock their doors because polar bears are so aggressive, so dangerous that if you are on the streets and you see a polar bear, neighbors, they allow you to come to their house. So it's a common practice not to lock the door. I saw this in a documentary. But then people consent, they allow, there's this neighborhood agreement. Yeah, if you are ever threatened by a polar bear, you just run and enter our property. All right, the last one before we go to a break. So now injurious falsehood. This is actually product defamation. There's another name called injurious falsehood or product defamation. So this is everything explained on defamation, but now related to a company, related to a service, to a brand. So again, if you say that Starbucks coffee comes from slavery farms, and this is false, they may sue you for product defamation or injurious falsehood, as it is. So this is a table summarizing all torts we saw. If you want to expand on this table, I would recommend you add a third column here and you add possible defenses available to those torts. But this is a nice summary for all the torts we saw until now. Questions? Comments? No? All right, so let's break. Let's make it 14 minutes. So you're back here 10 to 3, please. All right, so let's resume. This last part shouldn't take too long. So now we're going to look at some torts that are related to business, that may impact businesses. And by the way, remember we were discussing mainly intentional torts today, told you? And then on Wednesday, we'll be looking at the unintentional, careless torts. I just want to call your attention to defamation. Defamation may be intentional, but may also be unintentional. Okay, maybe by mistake. All right, so some other torts that impact business. First one, inducing breach of contract. Well, pay attention that the tort is inducing breach of contract. The tort is not to breach the contract. It is to induce someone to breach a contract or a company to breach a contract. Well, what is required for this tort. What is needed for an inducing of breach of contract torts to take place? What? A contract, yes. Can you induce someone to breach a contract if they are not in a contract? You can't, or even if you do so, they're not in a contract. So to induce a breach of contract is usually when people are lured, are offered so many benefits, so many things to get away from a contract and go to other. So let's say an educational institution, they know I have a contract with GCAT. They make me an offer to teach for them. And I say, no, thanks. And then they get back to me and say, hey, we can pay you more. And I say, no, thanks, I'm happy with GCAT. They insist and they say, hey, we can pay you double. We can even offer you paid vacation in Hawaii for a month. So they are trying to induce me to breach my current contract. Let's say I breach my contract. I go work for them. Who is the victim in this example? BCAT. So BCAT is the victim. And then BCAT is the one suing this other educational institution. Can BCAT sue me? No. Yes. Why not? Why yes?
He gets made for official punishment, but not for inducing.
Exactly. BCAT cannot sue me for inducing breach of contract because it was the institution, the educational institution who induced me, but they can sue me under contract, under breach of contract, because I had a contract with them and I did breach. Okay. All right. Another tort is the unlawful means tort. So it is a tort in which a party makes use of illegal, unlawful means to obtain a benefit or to cause damage, losses to others. So let's say you have a company and you supply sugar to Tim Hortons. And then I offer you some money under the table, bribery, to start supplying sugar to my coffee company. And then you stop supplying to Tim Hortons. So I'm using unlawful means, illegal means to harm your current client. And I will get the benefit from it. So that's an example of unlawful tort. Unlawful means tort. Could also be defamation. So I may come to you and I say, hey, can you lend some money? I know you have money. And you say, no, I will not lend you money. And I say, hey, I know what you did last summer. You don't lend me money. I will spread news to the class or to the community or whatever the group is. So I may be using defamation to make you suffer some harm or go into business with me. Threat, intimidation, another tort. This is when someone is threatened or they are victims of some other illegal activities and they suffer harm. So if I threaten you to lend me money without interest, well, no one would lend money without interest. Nowadays, it's not common. Interest is there. So if I threaten you with violence or with any other illegal activities to force you to lend me money, and without paying you interest, you would suffer some harm. And then you could sue me for intimidation. You only enter in that loan agreement because I threatened you to do so. Okay? Intentional infliction of mental suffering or nervous shock. So this is unfortunately common when managers, bosses, supervisors, they shout, they yell, they disrespect their employees. So employees may start developing this nervous shock, this mental suffering. And when managers, bosses, supervisors, they do this in an intentional way, they are intentionally inflicting people to suffer mentally. And you may have read or heard in the news that mental suffering has increased after COVID, during and after COVID. So torts like this have become more and more common for lawsuits for intentional infliction of mental suffering. It may be the case that as an employee, I was a victim of intentional infliction of mental suffering. I resigned. I sue my former employer, or let's say I am dismissed. I am wrongfully dismissed. So I may sue my employer or former employer for wrongful dismissal. And on the top of that, I may also add intentional infliction of mental suffering to it. So I may also seek further damages for having suffered such mental anguish. Deceit. So deceit is more common in contract law. When we talk about misrepresentation, I will discuss this in more details. The example there and here will be, let's say, you sold me your smartphone, you advertised your smartphone for sale, saying that the smartphone was purchased in 2020, and I wanted this one, but after I purchased it, I learned that it's actually a 2018, 2015 smartphone. So you lied, you misrepresented, and it caused me harm because I wanted a newer one. Okay, so this could be the tort of deceit, but because I purchased something from you, I would usually sue you under contract, under fraudulent misrepresentation. Now, conspiracy to injure is two or more entities or two or more companies, they get together trying to harm other businesses. So let's say all coffee shops here at BCAT, they get together, except the Ritz, but all others, they agree to set the coffee price at $1. Very low, so that they kill the competition, so that the risk goes out of business because they will not be able to sell coffee at $2.50, $3 or $4. So the other coffee shops, they got together and conspired to injure, to harm the Ritz. Okay, so that's conspiracy to injure. Again, two or more persons or parties, but they are acting together using unlawful means, and the result will be injury of the business. Passing off. Passing off is if we are using illegally the goodwill of another business. So let's say I have a famous coffee shop in my neighborhood under my name, let's say under my initials, JM. It's famous, but I don't have a registered trademark. It's just a famous small coffee shop. And then 2-3 blocks away, someone else starts another coffee shop, also named JM, similar color for furniture, the same type of pastries and coffee. So they are trying to pretend they are connected to my JM famous coffee shop, but they are not. They are trying to take advantage of the goodwill of my business, my brand. So under common law, I could sue them for passing off. So they were pretending to be connected with me, but they are not, and they can't. If JM were a registered trademark, then I could sue them for trademark violation, trademark infringement. But because I didn't register JM as a trademark, still JM is a famous brand in the neighborhood, I could rely on passing off tort, common law tort. In other words, what I'm saying is, and I will repeat this in chapter 13, what I'm saying is, even though you don't have a registered trademark, under common law, you still have a remedy, you still have a lawsuit available to go after those who are taking advantage, illegal advantage of your goodwill or the goodwill you have created for your business. Misuse of confidential information. Well, when do we get confidential information? When you are working for a company, you may get access to confidential information. What if I want to disclose confidential information to you? What if I created something, I have an idea, and I want to disclose to you, but I want to make sure this is confidential information? What should I do? Sign an NDA, okay? So what does an NDA do, or what's an NDA?
A binding contract of non-disclosure.
Yes. So the NDA is a non-disclosure agreement, meaning that the parties, they agree to receive confidential information and they agree not to disclose confidential information. Okay, in very brief words. But as someone who has confidential information, if I give you the information, if I disclose the information to you, how do you know that information is confidential or not? Straightforward. The discloser has to inform that information is confidential. Because if the disclosure does not inform, could be writing, could be spoken, you don't know. So if I give you details of a product, of a prototype, if I want this to be kept as confidential, I have to say, hey, what I'm about to disclose to you is confidential. Then I start telling you what this is about. Okay? And then if you are under an NDA, a non-disclosure agreement, or a CDA, confidentiality agreement, here, same. You cannot disclose confidential information to third parties, nor can you benefit yourself from that confidential information. And if you do so, you may be sued for misuse of confidential information. Or if you disclose, if you share confidential information with others, you may also be sued for improper disclose of information, or even breach of keeping information as confidential. So that's the tort. But again, you are only under such obligation not to disclose if you have signed an agreement, or if someone tells you in advance, hey, the information I'm about to tell you is confidential. The fact that I tell you it's confidential, it means that you cannot disclose it to others. If you do, you may be sued for improper disclosure or misuse of that information. Are we good? All right, now talking about privacy. So some torts related to privacy. The most common one is invasion of privacy. An invasion of privacy can be online, but it can also be physical. During the break, if you come to that PC that is logged on with my credentials, you may be invading my privacy. If someone comes to your smartphone that is unlocked or your laptop without your authorization, it may be invasion of privacy. If someone is using a drone to record what you're doing at home, invasion of privacy as well. So invasion of privacy can be online, but can also be physical. Okay, so that's the most common tort, and there's usually intrusion, surveillance, and even misuse of image, name, or any other information that was assessed. What else I want to share here with you? Well, there's tort law was primarily developed in courts. So through all decisions, cases and decisions, tort law formed. So it means that as society evolves, new torts may come into existence. An example is this tort of intrusion upon seclusion. This was recognized in Ontario. And because this was case law from the Court of Appeal in Ontario, it is case law there in Ontario, not in BC, nor in Alberta yet. Judges can use that decision here, but they are not required to. So the tort of intrusion upon seclusion was someone had access to a client's bank statement. So they worked at a bank, they had access to someone else's bank statement. And then they were sued for invasion of privacy. The court in Ontario, they understood that the best tort for such a wrongful event would be tort of intrusion upon seclusion, not invasion of privacy. The consequence was similar, but it's a new tort. So the Ontario court created a new tort. Just last year, the Alberta court, they came up with a new tort known as revenge porn. So a couple that have sex recording, and then when they break up, or even if they don't, but still, if there's sexual relationship recording, and that is disclosed openly, it's usually when the couple breaks up and one shares that video recording with others or online. So this is known as revenge porn. They do this on purpose to attack the other partner. So the Court of Alberta, they recognize this tort. People in Alberta, if they share those sexual relationship recordings freely in a way to make revenge to their former partner, they may be sued. They may have to pay compensation. I don't know how much they had to pay, but that is a recognized tort now. And it may not be a surprise to you that this tort may be recognized in BC, other provinces as well. And with the internet, with now artificial intelligence, there may be even new other torts coming throughout the years. So keep in mind that the torts we discussed today is not an exhaustive list. There may be others that may be created by courts. All right, that's what I wanted to share with you. Questions? Comments?